Ladies and gentlemen, boys and girls, it's Diego, and this video is about, in part, those 75 countries and those countries that are under a partial pause via the State Department and USCIS. So if you are married to let's say a Colombian or a Brazilian, and you are having your adjudication of your spousal visa green card blocked by the State Department, and if you're in the United States and you're under a pause by USCIS on one of those other 19 countries, then this video is for you guys, because in order to advance your green card application or your K-1 visa application, or your 2-year green card application in the United States, or your 10-year green card application, you should have some kind of legal pathway that you can go down in order to force USCIS and or the State Department to adjudicate your green card, your wife's green card, in accordance with congressional law. Okay, so listen to this video, ladies and gentlemen. Now, remember, no content of this video is legal advice. Okay, you shouldn't be considering this legal advice. I'm not an immigration attorney. And you don't, even though you don't need an immigration attorney to file a 2-year green card, 10-year green card, K-1 visa process, K-1 visa application. If you want to hire an immigration attorney, you can do so in order to move your case forward. But you really don't need an immigration attorney. So pay attention, class. This content in this video isn't legal advice. I don't work for USCIS, and I'm not an immigration attorney. Remember, each case is tailored to the unique circumstances of each case, of each person. Okay? Don't act on any information I give you without consulting a professional attorney if you feel that you need to do that, who is licensed and authorized to practice immigration law in your jurisdiction. So there's 75 countries that have been blocked by the State Department for adjudicating spousal visas, green cards for spouses, etc., based on, saying that these people from these countries are liable to become a public charge, which is basically absolutely bogus, because it's bogus information. The embassies are more than qualified to identify American citizen sponsors' income and block those folks, or look for joint sponsors for those folks that do not meet the income requirements. So when the Trump administration says they're going to block 75 countries from getting green cards, like Brazil, Morocco, Colombia, etc., it's totally a false narrative, because the embassies have the authority to actually block the green card if the income is not sufficient, or if they feel like the person is going to become a public charge. Okay, so my recommendation is this: if you want to, you can sue the State Department. You can file a lawsuit against USCIS without a lawyer. You don't need an attorney to do this, okay? But only if you have confidence in yourself to follow directions and listen carefully what I'm going to tell you. Okay, this is a step-by-step video to teach you how to file a federal lawsuit against USCIS on your own. For example, that your green card application is stuck in delays or was wrongfully denied. Well, there's those 19 countries in America, in USCIS are blocking, and the State Department's blocking 75 countries. This is a good case for you. Okay, so when you file a lawsuit against U.S. Citizenship and Immigration Services without a lawyer, okay, you can do that. It's legal. You can do it yourself, and thousands of people do it every year. Now, federal law requires your right to represent yourself in court, a practice called proceeding pro se. Okay, proceeding pro se. So number one, the first thing you're going to do is you're going to file the fee, which is $405 as of June 5th, 2026. And the process follows a specific sequence. But you must exhaust your options with USCIS directly, okay, and draft and file a complaint in the correct federal court. Make sure you file it in the correct federal court. And then you can formally serve the U.S. government for not following congressional law in regards to adjudicating your case within a timely manner. Now, most of these lawsuits target processing delays rather than denials, okay? And a surprising number resolve very quickly once the Department of Justice gets involved. So once you sue them, the Department of Justice gets involved and they want to get this solved as quickly as possible, okay? But before you file, these are the steps that will strengthen your case, and the courts expect you to try to resolve the problem with USCIS before you sue them. So skipping this step won't automatically kill your case in most delay situations, okay? But it will weaken your position and give the government an easy argument against you, which you don't want that to happen, right? You want to win your case and get your husband or wife or child his or her green card, right? So the first thing you're going to do is you're going to check your application status against USCIS published processing times, which the agency posts on its website and updates this regularly. Okay, number one. Number two, now if your case has been pending longer than the posted time frame, submit an inquiry through the USCIS e-request tool, which asks for your receipt number, okay, and a filing date. You want to do that first. You want to build a record of you contacting USCIS, trying to find out why your case is continuing to be denied past the timeline that they say they should have it processed. Number three, you want to keep copies of everything you submit and every response you receive. So print copies and keep copies of everything that USCIS sends you. These records become evidence that you gave the USCIS, you gave them a fair chance to act on your case before you turned it over to a federal judge. Now, if your case involves a denial rather than a delay, okay, the calculus is different, the math is different. Immigration law generally requires you to exhaust every single available administrative appeal before you file the lawsuit against them, whether it's USCIS or the State Department. So if USCIS denied your application and an administrative appeal exists, you typically need to pursue that appeal first with USCIS. Okay, this is if you get a denial. So filing in a federal court without exhausting your appeals gives the U.S. government a strong basis to get your case dismissed. And it will get dismissed, no doubt. Okay? So the legal grounds for suing USCIS, there are two legal authorities, or two legal theories, I should say, that cover the vast majority of these lawsuits. And you got to understand which one fits your situation to determine how you can build your case so you can win and get the green card adjudicated. All right. Now, a mandamus lawsuit is going to force a decision on a delayed case. So if you're from Colombia and you have your green card on block because of whatever the State Department is saying, you can force them to adjudicate your case. So when USCIS sits on your application way beyond the posted processing times without issuing any decision, you can file for a mandamus action. Okay? Listen up, ladies and gentlemen. Now, federal district courts, they have jurisdiction to order a federal officer or agency to perform a duty that is owed to you. USCIS, you paid for the service, you paid for the fees, your immigration fees, you qualify for the benefit, and now immigration is not adjudicating your case, or USCIS. So number 4, a mandamus lawsuit doesn't ask the judge to approve or deny your immigration application. It simply asks the court to compel USCIS to do their job and make a decision on your case. Any decision, rather than leaving your case in indefinite limbo, which is, in my opinion, mental abuse. In order to succeed, you need to show that USCIS has a clear, non-discretionary duty to adjudicate your application, and that the delay is unreasonable, like those 75 countries that are being blocked indefinitely. Courts evaluate reasonableness using a 6-figure test developed in case law, commonly called the track factors. Okay? Judges consider whether there's a reasonable timeline for the type of decision involved, approving a green card, whether Congress set any statutory deadlines. Remember, Congress created this process, not USCIS. and whether human welfare is at stake. Your mental health here, right? So would it affect the agency's other priorities, and how much is the delay harming you? The separation from your family is horrible, right? Now, there's no single factor with being decisive in this, but long delays on a straightforward application where the applicant faces real hardship will normally get adjudicated and successfully. Okay? Now, when you challenge an unlawful denial, if USCIS denied your application and you believe the denial was, let's say, wrong, right? You can challenge it under the Administrative Procedure Act. There's another avenue for you to look at through a federal lawsuit. The APA gives anyone harmed by a federal agency's action, the APA, the Administrative Procedure Act, if you have been harmed by the USCIS, you have the right to seek judicial review. So under APA review, a court can overturn an agency decision, a denial, that was arbitrary, unreasonable, an abuse of discretion, or otherwise violated congressional law. Let's talk about some common examples. Let's say include USCIS misinterpreting a statute, or ignoring evidence you submitted, or applying a policy that contradicts the law. The APA cases, okay, are harder to win pro se because you're arguing the substance of the denial, not just the fact of a delay. There's a difference. And the court's going to review everything, including the administrative record, meaning the documents USCIS had when it made its decision. You generally cannot introduce any new evidence. You have to go by what USCIS was given by you in the first place, and that's what a federal judge is going to look at. And you cannot add any new evidence to your case. Okay, so if you want to challenge a denial, remember the 6-year statute of limitations for civil claims against the federal government. So you got to do it within 6 years. And your clock starts running from the date of the final agency action that harmed you. The clock will start the day that your green card was denied. That's when the 6-year statute of limitation clock will start. You got to make sure also that you choose the right court. When you file a lawsuit against USCIS in a U.S. District Court, which they got to make sure that it has jurisdiction over the case arising under federal law, okay? And which the district court matters, is very important. Federal venue rules for lawsuits against government agencies let you file where you live, where a substantial part of the events giving rise to your claim occurred, or where where a defendant resides in your hometown. Now, for most people, filing a lawsuit in the district where you live, okay, it's the simplest choice. It's the easiest way to do it, and it saves you travel for any hearings, okay, and makes practical sense, since the events in a delayed case often center on the USCIS office handling your application. Okay, you got it? Make sure you file in the right courthouse. Some applicants will file the lawsuit in the District of Columbia because that's where USCIS and the Department of Homeland Security are headquartered. But there's rarely an advantage to doing so unless your case involves a policy change rather than a delay in the approval or adjudication of your 2-year, 10-year green card. Now, before filing, go to the court's website and download its local rules. Study the rules first. Each district has specific formatting and procedural requirements that supplement the national federal rules, okay? And if you do not follow the rules properly, this will result in your filing being rejected. It's going to cost you more time. Or you can just hire an immigration attorney to do this for you, but you really don't need one. You can do it yourself if you listen to what I'm telling you. So who do you name as a defendant? Well, you don't actually sue USCIS as a standalone entity. You name a specific government official and the agencies they lead. The typical defendant list for a USCIS delay case includes who? The Secretary of Homeland Security, right? The Director of USCIS, and the Director of the specific USCIS office or service center where your application is pending. So you sue a specific person, and in this case it's mainly going to be the director of USCIS or Secretary of State Marco Rubio, who is blocking those 75 countries from adjudication. So if your complaint raises issues involving the Attorney General's authority over immigration matters, you name the Attorney General as well. Include the Attorney General. Now, each defendant must be identified by their official title in the complaint. Okay? Director of USCIS, Secretary of State Marco Rubio. Okay? With the name followed by their title. And note, they are being sued in their official capacity, not personally. It's against them in their official capacity. So when a new person takes over the position during your case, the case will automatically continue against the successor. This protects you and keeps your case open if they change directors of USCIS, etc. Now let's talk about preparing your lawsuit documents against USCIS or the State Department. You need 3 documents to initiate a case: a complaint, a civil cover sheet, and a summons form. A complaint, a civil cover sheet, and a summons form. Okay, now the complaint, what is that? Well, the complaint is the document that starts your lawsuit. It identifies you as the plaintiff and the government officials, Director of USCIS, Secretary of State Marco Rubio, whoever, and establishes why the court has jurisdiction, and it explains what happened with your immigration case. Well, let's say you're in a poor country and you've been waiting 2 years for your green card. That's not good, okay? So then you can sue them. You're going to write a clear chronological account of your case. When you filed, what application type, the receipt number, what processing times USCIS publishes for that application, how long your case has actually been pending, and any contacts you have made with USCIS to inquire about this delay. So you want to make a chronological timeline of where you've been trying to fix this problem. And you end the complaint with a relief section, okay, a relief section which states exactly what you want the court to do. Typically an order compelling USCIS to adjudicate your application within a specified number of days, usually within 90 days. All right? You want to know, is your husband or wife's green card going to get approved? Yes or no? It can't be sitting in freaking limbo. Right? And you keep the writing straightforward and factual. No flowery BS, just straightforward and factual. The judges reading the pro se complaints are accustomed to imperfect formatting, but they need to understand the facts and the legal basis for your claim. You got to cite specific statutes giving the court jurisdiction and authorizing the relief that you seek. You want your wife to get her green card. She's from Colombia, and she's been put on a block for no reason at all other than she's from Colombia, right? So for a delay case, that means referencing the federal mandamus statute and the APA's judicial review provisions. Check your district court's local rules for page limits, margin requirements, and any required formatting. So you got to be an administrative guru here, okay? And then you're going to create the civil cover sheet. Now the civil cover sheet is a standard administrative form, JS-44, which is available on the court's website. Okay, it's easy to fill that. Print it, just print it. It asks for the names of the parties, the legal basis of the lawsuit, and a 3-digit nature of suit code. For a naturalization delay or denial, use code 462. So if you're trying to become an American citizen and they're just dilly-dallying around, you're going to use code 462. For other immigration matters like adjustment of status delays, adjustment of, waiting for the 2-year green card, waiting, use code 465.10. Okay, you got to get the code right because this helps the clerk's office route your case properly. Okay, and then you're going to have the summons form. Okay, you need a separate summons for each defendant and the summons is the court's official notice to each defendant that they are being sued by you. So you're going to fill in your name as the plaintiff and the name and address of each defendant, Director of USCIS and his office address, Secretary of State Marco Rubio and his office address in Washington, and you don't sign the summons, okay? After you file the complaint with the court, present the completed summons forms to the court clerk. The court clerk then signs and seals this for you, and then use the sealed copies for service, okay? You then use the sealed copies for service. So, filing your lawsuit with the court, most federal courts accept filings through their electronics, case management, electronics case files. You can do it electronically. There's a system that they have, which requires a PACER account. So you got to find out what a PACER account is, learn what that is, or hire an immigration attorney to do this for you. Okay? Some districts require pro se litigants to get special CM/ECF access from the court before filing electronically. Okay, so check with the clerk's office first about this, and you can also file in person or by mail at the clerk's office if electronic filing isn't available to you. If you don't want to do electronic filing, you can do it in person, okay, at the clerk's office. All right. And the filing fee as of June 5th, 2026 is $405, which includes the $350 statutory fee plus a $55 administrative fee. Okay, now if you cannot afford this, you can ask the court to waive the fee by filing an application to proceed in forma pauperis. You don't have the money, you're going to proceed in forma pauperis, which is a Latin word. Look it up. Now, this requires an affidavit detailing your income, your assets, and expenses to demonstrate financial hardship. Okay? You probably don't want to do that if you're trying to get a green card for your husband or wife, right? You want to be in a good financial position. So then the court's going to review the application and other grants or denies the waiver. Okay, it either grants it or denies the waiver. If you get the waiver denied, you're going to pay. If denied, you must pay the fee before the case proceeds. Okay. Now let's talk about serving the lawsuit on the U.S. government. Filing the complaint starts your case. When you file it, that's when the case starts. Serving it tells the defendants they're being sued. Marco Rubio, you're being sued for blocking these 75 countries. Director of USCIS, you're being sued for blocking these 19 countries from adjudication. Now, these are separate steps, okay? And you must complete the service within 90 days of filing, or the court can dismiss your case. Poof, they'll dismiss it. And don't treat this deadline casually. It's where many pro se cases stumble. It's like the 90 days you got to get married in America, right, on a K-1 visa. You got to do it within 90 days. The same applies to this lawsuit. When suing a federal agency, the rules require you to serve multiple parties. You must send a copy of the summons and the complaint to the U.S. Attorney for the district where you filed. So, like say here, Florida, the Attorney General in Washington, D.C., and the specific agency or officers you named as defendants, Secretary of State Marco Rubio, Director of USCIS. Okay, those are the two people. The most reliable method for a pro se filer is a certified mail with return receipt requested. The green return receipt cards become your proof that each party received the documents. You got to prove everything, ladies and gentlemen, boys and girls, in this case. You got to prove it from the evidence that you submit to them receiving the summons. After completing service, you must file proof of service with the court, and this is typically a short affidavit or declaration stating when you filed, how you filed, and to whom you mailed the documents to. All right? With copies of the certified mail receipts attached. You got to prove it. Without proof of service on the record, the court has no way to confirm the defendants were properly notified of this lawsuit that you're filing against them. And the 60-day clock for the government's response will not start running. So the government has 60 days to respond to your lawsuit, and it will not start running unless you do this. Okay, so what to expect after you sue once the government has been served the papers? Well, the Department of Justice assigns an assistant U.S. attorney, okay, to represent USCIS. That attorney will typically contact USCIS to ask what's happening with your case. What's going on? Why are Venezuelans on a pause right now for their green cards? Why? What's going on? This inquiry alone often breaks the logjam. USCIS may schedule a long delayed interview, issue a request for evidence, or simply adjudicate the application and approve your green card. They want to get it out from under their rug, right? This, in many delay cases, the whole point of the lawsuit is achieved within weeks of service before the government even files a formal response. They're just going to go ahead and get the green card issued to you so they don't have to get sued anymore, right? So like I mentioned, the U.S. government has 60 days from the date of service on the U.S. attorney to file its response to your complaint. Okay, that response might be an answer addressing your allegations point by point, boom, 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 or it might be a motion to dismiss the case, arguing that the court lacks jurisdiction. Make sure you file it with the right federal court, or that you failed to state a valid claim, or that the delay isn't legally unreasonable. So you've tried to sue them without giving USCIS enough time to adjudicate your case within their legally bound timeframes. Okay? So what happens if USCIS is now going to decide your case after you sue, right? After you sue them. When USCIS adjudicates your application after the lawsuit is filed, the government will almost certainly argue the case is moot, meaning there's no longer a live dispute for the court to resolve. So they might just go ahead and start processing your green card when they get the lawsuit and say they're in the middle of processing your green card, just to cover their butts, right? Maybe, in my opinion. If you filed a mandamus action asking USCIS to make a decision and USCIS made a decision, the government has a strong argument, right? And then at that point, the parties typically file a joint stipulation of dismissal and the case is closed and you get your green card. If USCIS approved your application, you're going to get what you wanted, your green card. But if USCIS denied it, you may have grounds for a second lawsuit challenging the denial under the APA. But the delayed case itself is over. So now you're going to move it. Okay, so USCIS denies your green card after you sue them. Now you can sue them again. Right? Open it back up with a new lawsuit. If the government decides they want to fight your case, that the USCIS could file a motion to dismiss the case, you'll need to file an opposition brief. You got to oppose that, explaining why the court should deny the motion. Okay, this is where pro se cases get a little difficult, where you probably need an immigration attorney. Now, the government's attorneys do this for a living, and their motions cite case law and procedural laws, okay, procedural rules, correction, with precision. They're like sharks in the Gulf area. Your opposition needs to respond to each argument. In this case, it's going to be you. Specifically, not just restate why you think your case has merit. You got to respond to the argument. And courts give pro se litigants some leeway on formatting and procedural technicalities. But if you don't hire an immigration attorney, this is going to be on you to do this. But they won't rewrite your argument for you. Read the government's motion carefully, research the cases it cites, and respond to this point by point. Now, your district court's law library or a local legal aid organization can help you find the resources that you need to do this. Or hire an immigration attorney if you don't want to do it on your own. If the case survives a motion to dismiss, okay, it moves towards a decision based on the merits, typically through summary judgment. Okay, and it's going to go through a summary judgment briefing rather than go into a full trial. And both sides submit arguments and evidence in writing, and the judge decides based on the record. You can do this yourself, or you can have an immigration attorney do it for you. In a delayed case, the court weighs the reasonableness factors and either orders USCIS to act within a deadline, or the federal judge will find the delay justified. Okay? In a denial challenge under the APA, the court reviews the administrative record to determine whether USCIS, okay, the decision they made was legally sound. So that's it, ladies and gentlemen, boys and girls. If you want to move your case forward, if you're from one of those 75 countries who are being blocked from adjudication because the State Department has classified you as all those countries as public charge possibilities, which is not true, you can sue the Secretary of State, Marco Rubio, and get him to open up your case. Other people have done this, and their green cards are being adjudicated. If you are from one of those 19 countries, I believe it's 19 countries in pause right now for green card adjudication in the United States, you can file a lawsuit against the director of USCIS, name him as a defendant, and force USCIS to make a decision instead of putting you into a permanent case of limbo, which is not what the Congress of the United States had in mind when they created this law. Thanks for watching the video, ladies and gentlemen, boys and girls. If you want to join as a member, you can join as a member down here somewhere, which gives you my phone number, address, email address. You can call me, text me, email me, and I'll be glad to help you. Okay? We do a live stream, Karina, my beautiful wife from Venezuela, Mondays, Wednesdays, and Saturdays, 6 p.m. Central. And if you want to, go over this video again, watch it as many times as you need to help you. But remember, if you are from one of those 75 countries or those 19 countries in indefinite pause in the United States by USCIS and the State Department, you have a legal right to sue the State Department and USCIS to force them to adjudicate your green card, whether it's for a successful approval or for a sad denial. But either way, the Congress of the United States did not create this program to put you in permanent, indefinite, legal limbo where you don't know what the hell is going on with your green card application. See you at the live stream, and thanks for watching.
I'll be back.